So hello everyone, and welcome to the second part of our colloquy for week 2. And this is being recorded, of course, in Springfield. And I just want to do some admin announcements, just like we did in Tumba earlier in the week, just to make sure that we are all on the same page. So if you now go to your specs for this course, you'll find that they have been changed as follows. First, everyone, regardless whether you are online or on campus, has to now do 2 online quizzes or tests. So there will be no marks for tutorials. Okay? So everybody has to do the first online test and the second online test. Now, as far as the exam is concerned, the exam is going to now be an open book exam. And some of you ask, what does that actually mean? So you can actually search for it on the USQ website, and it will tell you what that actually means. In a nutshell, you can bring anything that you want as long as it's in writing. Okay? So anything that's like the textbook or any other textbook, any version of the textbook, okay? Tutorial answers and questions, previous exams, your answers to those previous exams, okay? Your own notes, handwritten, all of that's fine, all right? What you cannot do yet is that you can't access anything that's in an electronic format because we don't want you to be able to access the internet. So that's what we have on open book exams. Again, this is, you can thank the previous cohort for these changes. It's the first time ever. I mean, we've been teaching this course since 2007. Not me, but the school has been teaching this course since 2007. And this is the first time ever that we are switching to an open book exam. I think that will make it much more easier for you, but don't let that be a false security for you, because it doesn't mean that you don't actually summarize and prepare. Okay? If you think that you're simply going to sit there and flip through the textbook for the 2 hours, you're going to fail. Okay? But I think it's still going to make it easier for you to pass the final exam. We'll see. We continue today with our discussion on chapter 4, and we're going to continue with the steps that Parliament takes to create a statute or to pass a bill. Okay? And the first thing we want to look at is the diagram on page 99. So of course we have started our discussion of this already in Tumba. And we're continuing with that, starting from this point. So the question is how statutes are made. Okay? So the starting point, of course, is that you have an idea. No? That idea could come from any number of places. It could be from members of parliament or from the cabinet, okay, public service, or even because of public opinion. And that would go to the relevant minister or department, which then should move it through the legislative committee of cabinet. So there will be a tabulation of a number of ideas. It will go then to something called the Office of Parliamentary Counsel. These are the people who will draft the bill for you. And then it goes to Parliament. In Parliament, you're going to have 3 readings. Which Parliament are we talking about? It doesn't matter whether it's the state Parliament or the Commonwealth Parliament. It's going to go through the same procedure. In fact, even in other jurisdictions that are based on the Westminster style Parliament, you'll find that they also follow the same procedure. So the first reading is simply mechanical in the sense that it's just a routine, it's just a formal introduction, And the same thing applies to the third reading. Okay? The changes and the discussion and the debate that goes around any bill comes through the second reading, especially if it's referred to what's known as standing committees. So these committees would go on and look at certain issues of concern relating to the bill, and then it comes back to the Parliament. If it's passed by the House of Representatives, which is the lower house, then this same procedure is going to repeat it again, but now at the Senate level. Okay? So of course in Queensland we don't have a Senate. So once you have passed it through the House of Representatives, then that's the end of it. But if it's a Commonwealth, for example, bill, it will have to pass through both houses. Okay? Then it's enacted. So once we have agreed on the bill, we voted and it passes, it gets the royal assent from the Governor General, which is of course the representative of the British monarchy in Australia. And finally it's gazetted, or it's sent to the Gazette so that people know that we now have this new act or new rule. I believe one of the participants online needs to mute their mic. I'll just mute you, Claudia, if you don't mind. If you need anything, just let me know. So you can just raise your hand. And if you need to participate, either one of you, it will be fine. All right. So this is just in a nutshell what we do for the passing of statutes. So again, there's a notice, and that's followed by a formality called the first reading, a second reading where we now take this bill to a committee usually, and then from there it goes to the third reading after a report comes back from the committee, and then it goes from the lower house to the upper house, and if it goes through both successfully, it ends up with a royal assent and it becomes a law. Now I want to talk about something quickly that's known as double dissolution. Okay? This is of interest mostly to people who are doing constitutional law, because it doesn't happen that often. So the discussion is on page 101. Of course, this book hasn't been updated yet, so it talks about the double dissolutions that happened in the 1914, 1915, and 1974 elections. But now, of course, we also have another one that happened just in the last federal election in 2016. So the government wanted to pass a certain bill in relation to the construction industry and the watchdog for that industry, and the bill failed to pass in the Senate 2 times already. So they had to go to a double dissolution, which means that they had to go to election early. Okay? Let's watch something about how this actually works. And as I said, it happened only 4 times during our constitutional history. It's just a short ABC clip. All right. All right. So I think that's enough on double dissolution. It's just the idea that it is something that doesn't happen usually that often, and it happened just recently in the last election. All right. Let's then move on and talk about this part of the course that we call critical thinking and legal analysis. So how do we interpret statutes? Okay. Now, historically, of course, we relied on common law rules or principles to interpret statutes. Okay. And over time, these things became now what we call the Acts, Interpretation Acts. And there's a summary in your book of these acts in Australia, which is on page 107. So if we just look at this is what now we have as Acts, Interpretation Acts in the 9 jurisdictions in Australia. And the key point here is that there was an evolution over time from a literal interpretation of what we have in statutes. So we always looked at black and white interpretation of the words or expressions in these statutes. However, over time, we evolved, as I said, towards a more purposive approach. Purposive approach, which means that the importance, the focus shifted more towards the reason for enacting a certain section or a certain act. So in a sense, we now really ask, what's the purpose behind this instrument, legislative instrument? Although we still also look at the literal approach, but not as an end, maybe as a starting point, but always looking also at the purpose of these acts. You can make analogies between this, of course, and something that we have in religion, although that might not be of much interest to you as business students. The Law and Justice School just created a new research group called Law and Religion. But there, you can also see that there are analogies between how we evolved in interpreting laws and how we now also think of religion. But that's just a different matter. All right. As part of this new approach under these Acts, Interpretation Acts, and in order for us to ascertain the purpose behind these legislative instruments, we also look at something called extrinsic materials. Okay? Extrinsic materials. So we looked at the case on page 107, the Warmundo case, Warmundo. And there we said that the court wanted to understand or establish whether a stock route was caught by the sections in the Act in that case in relation to public roads. And in order for us to understand whether that was the intention, the purpose of the Act, we went back and looked at the second reading of the bill when it was going through the Parliament in the Northern Territory. So, in a nutshell, in order for us to understand the purpose behind an act, we can also look at extrinsic material, i.e. material outside the act itself. For example, this idea of looking at the speeches that were made in Parliament in relation to this act, but also in relation to the idea of what's known as the Hansards. Okay? Now, the Hansards are discussed very briefly, really, in your textbook, and you just need to know the meaning of what a Hansard is. And if I can find that for you, it is on page 87. Okay, so it says there web resources, but Hansards basically are reports of parliamentary proceedings, which you can access actually free of charge on the parliamentary websites. And these would be considered as part of our extrinsic material that we could use to interpret a certain statute. Okay? When you apply this to the Constitution, the Australian Constitution, as you have probably read in your textbook, our Constitution, the idea of federation, came through a series of constitutional conferences, conventions. And these were also ended up in written format. There was proceedings for them, so something very similar to Hansards, and you can still access them free of charge online. So sometimes if you want to interpret certain sections of the Constitution, the Commonwealth Constitution, you can always go and read again these debates that we're going through when the Constitution was still in a draft format. All right. Okay. Let's then look at some more detailed analysis in relation to the rules that we apply for statutory interpretation. So we looked a little bit about at extrinsic material. Let's look at common law rules. Okay. So as we said, the starting point was this literal approach. So this is from common law, and this is really historical. So we're not going to spend too much time on it. But basically, they said that what we will focus on is just the meaning of the words. Okay. So we will look at certain cases as examples of this approach. Okay. Certain cases starting from page 104. So the little approach was basically to look at the actual meaning of the words. Then there was the golden rule, and the golden rule said if you look at the actual meaning and you end up with some sort of an absurdity, okay, then you'll have to go beyond that meaning, either absurdity or injustice or repugnancy, in the sense that there is a tension between different rules that needs to be resolved through our interpretation. Then you are able to move from that plain meaning and look at the purpose of the act. So this is really the origins of how we ended up now with the emphasis on the purpose in statutory interpretation. Then there's the mischief approach, which is very similar. And it says that the courts look at the law before the statute was passed, look at the overall intention of the legislation, and ask what mischief is the statute intended to remedy. So let's look at some examples in relation to these. Then we will continue with some discussion of at least most important maxims in relation to common law. But let's then focus now on these three cases. So the first case is the example of Fisher and Bell on page 104. Okay. So you can see this is a very old case now, 1961. Who can tell me what QB stands for? Queen's Bench. Is this a law report? It tells us that this was in the UK, and it was a case from 1961. All right, the facts. So we have a shopkeeper, his name is Bell. Bell had displayed a flick knife in his shop window with a price tag on it. So there's this object in the window with a price tag on it. He was charged okay, by Fisher, who's a constable, under the Restriction of Offensive Weapons Act of 1959. This is a UK act, which, among other things, stated that, so this is from the act, any person who sells, lends, or gives a flick knife to any other person commits an offense. Okay? So the legal issue was what? Was bills displaying of this flick knife caught by this act or not? In particular, as it says, does placing the flick knife in the window with a price tag amount to a sale or an offer to sell? So the court said, in the absence of any definition, okay, in this act extending the meaning of offers for sale, according to a literal interpretation, that's what we're looking at. How do you do a literal interpretation? Bill had not committed an offense. Why? Because the display of goods in a shop window only amounted to an invitation to treat. Of course, this is something we'll look at in some more detail when we look at contracts. And we compare and contrast the idea of an offer and an invitation to treat. The key point is that when you make an offer, you intend to be legally bound. Yeah, that's the first part of an agreement under the classical analysis of a simple contract. But if you make an invitation to treat, you are not actually saying I'm legally bound. And that's the difference between whether you are selling or not. If you were making an offer, you are actually binding yourself legally to give the knife, to sell the knife. And then you would have been caught by this act, so you have committed the offense. However, if the court comes back and says, no, you are not making an offer. You are simply making an invitation to treat, so you are not actually binding yourself, and hence, so we're talking about the literal interpretation, literal approach. Okay? That would mean that you are not bound, that you are not caught by this offense. Let's look at the comment here. If hardship results from applying the literal meaning of the act, it's up to Parliament to correct the hardship by passing an amending act. What does that mean? So it's saying it's not the court's job, okay, if they see that there is some sort of a problem or defect with the act, that they go and substitute their own interpretation for the act. That's something that has to be left to Parliament, because Parliament is what? Is democratically elected. That's the main point. Okay? Judges are simply administering the law, the creation of law, and if there are problems, solving those problems is the function of Parliament. So it says again, case is interesting because it involves the offense of selling a flick knife. So this is criminal law. But the court applied contract law to determine if the offense had occurred. This is a very general point about the law. We said at the very beginning that the law is a complex system, so it doesn't have really even one definition. But in order for us to be able to teach the law, we have to squeeze it into silos. And those are the substantive areas we refer to as criminal law, or contract law, or tort law, and so on. However, always remember that these areas have overlaps. So for a proper analysis, once you have learned these substantive areas, you have also to be able to see the full picture. You have also to be able to see the interaction between these areas. So in this case, this is an offense. It's a criminal offense. So most likely you get either imprisonment or a fine if found guilty. But the court, in order for it to ascertain whether this criminal offense occurred, had to look at a very different area of law. It had to look at contract law to ascertain whether the offense occurred or not. Now let's look at the case reflection. If a hardship arises from applying the literal meaning of an act, should the courts be concerned? You're a judge. Okay? If you were a judge, what would you have decided in this case? Do you think that Bell should have been found guilty or not? Why not? Someone says no. Why not?
Because that was an imitation of the truth.
That's the technical argument. That's the technical argument. But do you have anything around equity, around fairness?
But that's not the court's reason. The court's not supposed to be there to be equitable. It's supposed to be there to, do what it's told.
So do you think that the courts should look at this idea of fairness or not? Do you think that courts should simply implement the black letter of the law? You want to elaborate? What do you mean by no? Should the courts go beyond the black letter of the law as a judge? Or are you simply applying a technical argument without having to worry about whether the end result is fair or not?
Stick with the technical arguments.
So someone here says stick with the technical argument. Anyone wants to challenge that?
Yes.
Yes. What are you going to say to that argument? Why do you think that we as judges, if we were judges or the courts, should be fair?
It goes case by case. It can't just be black and white. Yes, the law says guidelines, but that's what the judge is there for, to find grey areas.
And what's the problem with that argument? So judges should be what? More active?
Yeah, more active.
Okay. What's the problem with a judge that's more active? So they want to go beyond what Parliament said. They want to go beyond simple, interpretation of the law. They want to be just. They want to be just. What's the problem with justice?
The judge could have self-interest, and also the judge is not actually elected. So sure, they may have been employed by the government or something like that, or some other agency, but that doesn't mean that they're representing the people. They're more representing their own ideas.
Okay. So someone here said it is actually the problem that they are not elected. Okay, and you said that they shouldn't be active because they might actually follow their own interests. Okay. Has anyone followed what was happening with the Supreme Court in the United States, or generally what's known as judicial activism? Okay. So this is the problem we refer to as judicial activism, in the sense that historically you'll find that some of the most famous or most brilliant judges actually were very active, in the sense that they went beyond the requirement or the function of judges or the court system to simply administer the law. Again, there's no right or wrong answer. So it's just a matter of reflecting on the case and understanding that you are looking at complex issues and you have different arguments for and against. Okay? You need just to understand that these arguments exist. So when you take one side or the other, you are also respectful and cognizant of that other position. All right. Let's look at the next case, which is the Lee case on page 105. So we just looked at one case, which is the literal interpretation. Let's move on and look at the golden rule. Again, these are old cases again, 1967, Queen's Bench. So it says Lee was involved in a motor vehicle accident. It doesn't matter, okay? We're going for something else. He stopped only for a moment after the accident, and then, seeing that no one was injured, drove off. Yes? There was a car accident. The guy stopped to see what happened. No one was injured, so no worries, keep going. So, because he simply drove off, he was charged with an offense. This time under the Road Traffic Act of 1960 from the UK. What's important is this. Section 77 rather, subsection 1 says, if in any case, owing to the presence of a motor vehicle on a road, an accident occurs whereby damage is caused to a vehicle other than that motor vehicle, the driver of the motor car shall stop. So if there were damage caused to a vehicle other than that motor vehicle, the driver of the motor car shall stop. What's the legal issue? Could it be argued that the requirement to stop was satisfied if this driver halted momentarily? So, just like this guy did. He stopped, checked the situation, and then drove off. So, his actions, okay, do they satisfy the requirements under the section 77, subsection 1? So you can see that the decision looked at the intention. What's the intention behind this rule? And the court said the intention was that the driver shall stop and remain stopped for as long as necessary for anybody who has a right to do so, to personally get any information which they may require about the accident. So they said how long you stop is determined not by whether someone has been injured or not. You need to stop for a period of time that's necessary for anyone who has a right to get information about you and your car to do so. Again, it says to apply the literal or plain meaning rule here would have produced an absurd result. Of course, the absurd result would be what? That this driver has complied with the act because he stopped and then he drove off. Okay? So the point is, sometimes the literal interpretation would give you an absurd result. So you need to go beyond the literal meaning of stopped and look at the purpose of stopping, i.e. the purpose of furnishing information about the accident rather than simply that you just stop momentarily or that someone has been injured. Now again, we have a reflection here. Why would an application on the literal or plain meaning rule have produced an absurd result? What is the source of this absurdity? So again, if you use the literal approach, is this driver guilty of an offense or not? No. Why? Because they stopped. This is the literal approach. Is this outcome absurd? Someone nods. Yes. Why is it absurd? Anyone? What's wrong with it? Yes?
One of the things I noticed was wrong is that it doesn't actually tell you in the sort of explanation how long you're supposed to stop. So you could stop the car indefinitely in an example and just be there to be dead.
Yeah. So we'll see that the act itself is not clear on how long you need to stop. But how is that then relating to this point of absurdity? If we say that the driver has complied with this act, what's silly about that? What's absurd? Someone says it's not the intent of the act. Can you elaborate? What does that mean?
Like they want you to stop so that people can get the details, and by applying the rule, it's not doing what it's meant to do.
Okay. So he says the intention here is that you stop so that people can get your details. And why is that? Why do you want people to get your details? You need, for insurance purposes? Yeah.
That's someone's injured as well, so they know.
Okay. Someone is injured, so they need to know your details. So would it not be absurd if you would have said that he has complied with the act? And I'm trying to get to you is again this idea of common sense. Okay? Or if you like to look at it from the economics perspective, the idea of efficiency. Okay? Laws, whether they are rules or principles or doctrines, but the purpose of an act, I'm looking at a much wider, or I'm using a wider lens, okay, rather than the literal approach, which really looks about the rules, and especially the meaning of the words that were that constitute the rule. So in other words, I could write this section 77.1 in many different ways to come up with the same purpose, which is really protection of the injured party, an economic outcome. It doesn't have to be written this way, but every time you write it, you'll also find some defects. Again, because of economics, because it's very expensive to be able to capture all possible outcomes or contingencies by writing a comprehensive sort of version of this section 77.1. So there will always be some problems. You know, how long do you need to stop? And we don't have to cover all of those eventualities because it's expensive. So what we usually do is to capture the most important features of what we want to do, here being the protection of these injured parties, and then we leave it to the courts to interpret that along these purposive interpretation. Let's look at one more example. This time, it's the mischief approach. Okay? And our case is on page 106, Smith and Hughes. Still the Queen's Bench. This time is something called the Street Offences Act of 1959. Okay? It says the act prohibited soliciting by prostitutes in a street. It doesn't matter what we're talking about. You see, very different types of laws, but we want to see how we are caught by this idea of how you interpret the act. Here's an act. It's about prohibiting prostitution. And it says you are not allowed to solicit in a street. Okay? So find customers in a street. To try to get around the operation of the act, prostitutes began to try to attract business, i.e. customers, by standing at their windows or on their balconies and calling out to passers-by. Okay? So this is about prostitution. The act says you cannot solicit, you cannot find customers on the street. So a prostitute cannot actually stand on the street and talk to someone, you see, to try and find business. What did they do instead? They tried to communicate with these passers on the street, not by being on the street itself, but from their windows or from balconies. So the issue, of course, did the act extend to include the activities of prostitutes who attempted to attract business from windows or balconies? Or did it catch only the activities of prostitutes who were actually soliciting on the street? What do you think before we continue reading? If you want to apply the purposive approach, okay, the purpose here is what? What's the purpose of this act?
To stop sex workers.
To stop sex workers? Yeah. So do you think, if you were the judge, do you think you should still apply this on the street interpretation to someone who's actually calling from a window or a balcony?
It's affecting somebody in a street, so you can sort of say that's half and half, but unfortunately half and half doesn't really work in court.
Sure, but we're saying that, yes, so someone's saying it's half and half. But again, what is the purpose? How do you give effect to this purpose? Yes?
If the purpose was to stop sex work as well and just say prostitution was illegal, it sounds like they want to prevent them from doing business on public property, i.e. the streets or footpaths.
Okay.
It doesn't say prostitution.
So, an argument here is saying that this act does not intend to stop prostitution. The intention is not to stop prostitution. The intention is to stop prostitution in a public place. Let's run with that argument. If that's the case, do you think that someone who is soliciting from a window or a balcony should be caught by this act? So most people say yes. Anyone says no? No. Why do you think they still shouldn't be caught by this act?
Because they're not in the street. They're not in a public place.
Because they're not in a public place. So
But it's not.
so someone says, but they're yelling in a public place.
Can I counter that there as well, where it's kind of, you can just easily imagine, like, it would be the equivalent of, having you know how they put TVs on bus shelters? Imagine if they had a half-naked woman dancing around saying, ring this number. That is essentially the same logic as that. It's not, like, it's, sure she might be standing in a private place, but it's being advertised
But they're
out on a
actually
public.
buying stuff. They have to be in a public place, not in a private place.
Yeah, but it
But that person is a
the advertisement.
Come again? Yes, someone new here? Yes?
If she's standing in a window, the property might actually belong to her.
Okay, so someone says, what really this stands on is whether you are in a public place or not. Yes? So you're saying, if they are in a public place, this should be prohibited. If they are in a private place, this property, for example, belongs to them, they can do whatever they want. All right. What did the court say? So, the words in a street extended to include the activities from windows or balconies. Why? This is the ratio, right? This is the ratio decedent die. Why is that? Why did you extend the street all the way to the balconies and the windows? As the mischief that this act was directed at was to allow people to use the streets without being solicited. So how is this argument different from the argument we heard earlier? Someone said that the idea here is not to prohibit prostitution, but the idea is to prohibit prostitution in a public place. Right? How is this argument different? Because when you said that, the outcome would be if you are on a balcony or in a window, then you are not in a public place, right? Is that the argument you made? How did the court differ from you? And why? What did they stress? What was the emphasis?
Solicited. Sorry.
Someone said solicited, yes?
I think it's more sort of like so people would be able to wander down the street without kind of being hounded and sort of saying, what they say is probably not really appropriate to say in class.
So, you see how important it is to understand the purpose? If you say the purpose is to prohibit this prostitution on a street, it's very different from saying you want to protect the people on the street. It gives you a different outcome, doesn't it? This is similar to the motor vehicle accident we just talked about earlier. Both of them have the purpose of what? Of preventing the accident, of protecting the person who would be injured by such actions. Okay? Protection. What is the reflection? Does application of the mischief rule undermine Parliament's supremacy? Here, so what does that actually tell you? The Parliament intended what behind this act? What it says, prohibited soliciting by prostitutes in a street. The literal interpretation. But what did the judges do, the court? They went beyond that to look at the mischief behind this action. The question is that an infringement on Parliament's supremacy? First of all, what do we mean by Parliament's supremacy? What do you mean by the Parliament is supreme? Yes?
Parliament's kind of at like a higher point over the court, so it's able to sort of establish the laws, and then the court's supposed to carry through the laws.
So someone says they're supreme because they are the highest law-making body in the land. And why is that? Why is Parliament the highest law-making body in the land? Because they were democratically elected, unlike the judges. Do you think that here the court was right in applying this mischief rule, and again looking at this idea of justice? Or should they have limited their role to this application of the literal approach? Someone says he thinks it was right. You want to add?
I think it was right because they were still kind of acknowledging the purpose of the law itself and what it was trying to, what I've written down is detract, but I don't know if that's the proper word for it, but what it was trying to sort of eliminate from society.
So I think there's more of a consensus that it is reasonable to look at the purpose and not stand at the very beginning of the interpretation and limit yourself to the literal approach. Of course, that's what we have now under the Acts Interpretation Acts. All right. Let's continue. As I said, just continue until we finish. I will finish soon, and then we'll start in the tutorial. All right. So we're done with these. Let's look at the maxims. We're going to limit ourselves to two maxims. So they are sometimes called canons of interpretation. And you find that they are still given to us in Latin. So we're going to look at two of these. The first is known as Noscitur a Socii, and the other is known as Jusdem Generis, or sometimes referred to as Jusdem Generis. What are these things? So these are rules that help us interpret what we read. It could be in a statute, or it could be anywhere else. All right, let's start with the first one. So here we talk about what's known as the context rule. If you don't want to remember Noscitur a Socii, just remember it's the context that we are trying to find. What is the context? So this maxim is helpful where we want to ascertain, okay, the meaning of a word which has a number of meanings. And it stops this word, limits rather the word, and stop it being used too widely by looking at its context and trying to determine its meaning from all the surrounding circumstances. So let's look at an example in your textbook. Let's look at Noscitur a Socii, and let's look at this example. So it says, in R and Ann Harris, R stands for what? Yes? Someone said something? R stands for Regina, which means we're talking about the crown. So what type of law is this? Is it civil or criminal? Sorry? Someone says criminal. Anyone said civil? What? You said civil. Why do you think it's criminal? Who is the movement? One of the parties is whom? The state. So we said when you have something where the state is prosecuting or actually on the defense even side, what would be that? What kind of law is that? It's part of public law, and because it's the state that's involved, it is criminal law. Okay, so what about this case? Again, 1836. There are these words. If any person unlawfully and maliciously shall shoot at any person, look at the language, 1836, or shall, by drawing a trigger or in any other manner, attempt to discharge any kind of loaded arms at any person, or shall unlawfully and maliciously stab, cut, or wound any person with intent in any of the cases aforesaid to maim, disfigure, or disable such person, or to do some other grievous bodily harm to such person, were considered by the court to cover only wounding by an instrument, not by hands or teeth. Let's look at it one more time. So the question is, if we look at this, so we're looking at this context rule, nos scriptura sut si. And the issue is, what is covered by this statement? If any person unlawfully and maliciously shall shoot or shall, by drawing a trigger, attempt to discharge any kind of loaded arms, or shall stab, cut, or wound, okay, with intent to maim, disfigure, or disable, that would be considered an offense. The question was, in this context, would you also include wounding by hands or teeth? So if someone wounded someone by biting them, okay, based on this context, do you think the context of what you read here includes the idea of wounding someone by biting? Why is that? So the court tells us it doesn't. Why it doesn't? How do you come to that conclusion? So you look at the context. What is the context of what we're reading? So shooting, drawing a trigger, discharging, stabbing, or wounding. So the question, the wounding here, does it extend to wounding with your hands or by biting? The context again is where you have something like shooting or drawing a trigger or discharging or stabbing. All of these things have what in common? Using and, sorry? Intent, yeah. But what else? Using an instrument. That instrument could be like what? Give me an example. What does it say instruments like what? A knife, because you are stabbing. Or, okay. So that's why we would say, if you are interpreting this, it's more likely than not that this thing in relation to teeth and hands would not be caught by this, based on what? On this canon of interpretation known as the context rule or nos scriptura sut si. Let's look at the next one. So let's look at the jusdem generis. And this is known as the class rule. And it's used when general matters are referred to in conjunction with a number of specific matters or a particular type. Again, it limits the general word to the same class as to the more specific words preceding it. Let's look at an example. So, let's look at this example. It says, so this is something we're reading, right? We want to interpret it. It says, any house, flat, villa, unit, or other building, and we highlighted or other building, because that's the term that's general, right? House, flat, and villa, unit are all specific. But when you talk about or other building, that's the open, wide sort of clause that we want to understand what other building means. Okay? So, the word building, it says, is limited. The word building is limited to the same class as that which precedes it. And what's the limiting thing here? Yes?
Wouldn't it be easier to say house, place, building, unit, or other dwelling?
Absolutely. But we are given something we haven't written. And our job is not to rewrite, our job is to interpret. Okay? The text is given to us. Our job is to try and understand why this person who wrote this text, could be God himself, why did he choose or other building? And we're saying the starting point, because this is the general term, is to look at the specific terms that preceded it. And try to see if those terms can be formed into a class. What does that mean, class? It means that they have something in common. What do you see something in common between these words? House, flat, villa, or unit? Man-made, yes. And more abductively, so the closest reason, again we're talking about reason here. What's the most reasonable interpretation of these things? As it tells you here, they all refer to what? Places where people live. Premises. That was the reason why someone said, why shouldn't just say, another dwelling? Okay? So the way you apply this class rule is to see that there is actually a general term. You really don't understand what it includes, but you can find that out by looking at the previous words. Okay. Let me just say that you find in a certain legal instrument the following words. Assault, violence, or any other type of aggression. Assault, violence, or any other type of aggression. Can someone explain to me how do you interpret any other type of aggression? Is there a class that links violence and assault? Someone says, talks about physical harm. Using, what do you use for physical harm? Yeah, but how do you use that? What is the impact of the weapon? How do you make the harm? Force. Thank you. Lulu was sleeping in a meadow. I know Lulu. I saw her. So I went to her. And just whatever reason, I kissed her on the cheek. Assault, violence, or other forms of aggression. Would that kiss qualify as other forms of aggression? But we're looking at what we're looking at. We're trying to do this jusdem generis. The jusdem generis, the class rule says what? There's this general term, which is other forms of aggression. But how do you understand this other term? By looking at the previous specific terms, which should form a class. And we said that assault and violence they have a common denominator, which is what? The use of physical force. When I kissed Lulu, did I use any physical force? No? So what is the definition of force? When you kiss someone, what happens? You apply what? You apply your lips to their cheek in this instance. Okay? Is that a force? Is that a force that's caught by the term any other form of aggression? So someone says, no, because this force, even if it's a force, it did not create any harm. Is that a common denominator? Is that a common denominator between assault and violence? So someone says there's an emotional aspect to it. Do you think there's an emotional aspect to assault and violence?
It's intent.
Just out of curiosity, and we'll talk about this more when we talk about criminal law. If I want to assault you, do I actually have to touch you? So most people say no. In order for me to assault you, I really don't have to touch you. What do I have to do? Intimidate. It's an emotional scar. And it depends, because if it's a child would be intimidated by something that maybe, a rugby union player wouldn't be intimidated by. Okay? All right. Let's look at other examples. Let's look at other examples of how we apply these things. So, here's an exercise. It says an act, i.e. statute of parliament, because it's capital letter, right? Stipulates that floors, steps, stairs, passageways, and gangways had to be kept free from obstruction. Okay? The act that we are looking at, the text is saying this. Floors, steps, stairs, passageways, and gangways had to be kept free from obstruction. Now the question that we need to answer, is a floor used exclusively for storage? A floor used exclusively for storage. Is that caught by this sentence? Is it caught by the act? I.e., should a floor used exclusively for storage be kept free from obstruction? So, two things I want you really to leave this course hopefully with. Okay? Again, we're not training you here to become lawyers, but two things, give me these two things please as you pass the course. Never ever answer a question, well, there's no such thing as never ever, but most likely, or more likely than not, when someone asks you a question, never answer the question yes or no. Okay? That's not good enough anymore. So it's always going to depend. The answer is always, it depends. Because we're looking at complex issues here. Secondly, never ever jump into a conclusion. Okay? No one is pushing you or rushing you to come to a conclusion. So even if people ask you questions, you have to take them through the journey. You have to take them through your mental process. And that's where you get the marks to pass on the exam and the assignment. Part B of the exam and the assignment. I'm not interested with your answers. Don't just tell me, it's going to be negotiation. Yeah. Use negotiation and litigation. I'm going to go say, yeah, great, okay, yeah, no. That's what I'm looking for. I'm looking for why. So, who wants to take me through the journey now?
The common denominator,
yeah.
Floors, steps, stairs, passageways, and gangways, they are used to travel from point A to point B. They're used to walk through.
Okay, so someone is looking at what? A common denominator of these floors, steps, stairs, passageways, and gangways. So which rule are you trying to apply here? Is it the context rule, the noscitur associé, or the class rule, the jusdem generis? Are you looking for a context or for a class? So someone says it's the context. Shall you take us through that a bit more?
I was thinking kind of similar approach, which is like, when it says kept free from obstruction, does it mean, is it sort of like, if it says it's a storage room, that's different from a room which actually has a fire exit, which would actually be more sort of addressing the context of it, is that a floor in a storage room, of course, would be used for storage.
All right, good explanation, but let's simplify. How do you know which rule you need to apply? Is it the context or the class? When we looked at the class rule, the wisdom generous, we were looking for what?
Any other type?
Yeah, so it was something like any other type of aggression, for example, or something like, or other buildings, yeah? So there was this wide phrase, and you wanted to understand how wide you can interpret that, okay? That's not what you have here. There's no such thing as other types of whatever, yes? So you know that you're not looking at class. You're trying to establish the context. So what is the context in this case? Floors, steps, stairs, passageways, and gangways had to be kept free from obstruction. What is the context? What is the context of all of these things you're looking at?
Is the storage being obstructed?
So forget the storage for a moment, because let's establish first the context. What about these all these things together? What is their context? Someone talked about a fire exit. So
That has to be sort of like a free passage to actually get to another space. Like if it's just kind of a thing which kind of gets you somewhere but nowhere, or a passageway to nowhere that can be possibly obstructed as long as it doesn't.
all right. So someone says the reason for this obstruction thing is that you want to make sure that these type of things are giving you what? A passage. In case, for example, of an emergency, if leading to an exit. Do you see that? Is that the context or not? Is that the context why we are talking about these things have to be kept free from obstruction? Yes? Okay, so now let's take that and look at this idea of a floor used for storage. What does that mean, a floor used for storage? Is there an exit?
No.
Most likely than not, is there an exit? So do you think then that should be caught by this or not? Okay. Now someone else might say, of course there's an exit. Because you have to make sure that if someone inside, they can run away. They can exit. And based on that argument, you would say what? That this floor is actually caught by this act. It should be free from obstruction. Of course, then you have to think about how is it going to be from obstruction if it's used for storage. So the key point is, I'm not interested in yes or no. I'm not interested in it is caught by the act or it's not caught by the act. What's important is why. Why? The reason, the purpose. Okay? That's where I want you to go. Why? Let's look at something else. It says, this is another one, an act prohibited the keeping of a house, an office, a room, or other place for the purpose of betting. The question is, would this apply to a race course? So the act has something like, prohibits the keeping of a house, office, room, or other place for the purposes of betting. Okay, what about if it's a race course? Would that be caught by this act? Again, don't say yes or no. Explain which rule you would apply and why you would come to a certain conclusion or otherwise. Yes?
That is the class rule there.
Why is the class a class rule? This is used in generous because of the existence of this phrase that says or other place. Our problem is what? To see whether this race course is another place. Or other place. Does that include a race course? How would you find out yes or no?
You would look at sort of all three of the places and figure out what they've got in common.
The class. So let's look at these things that come before this general term and see if they have a common denominator. It says house, office, room. What is a common denominator here? Someone else maybe. What is common between the house, the office, and the room? Are they all dwelling places?
Yes.
Maybe? What is special about a house, office or room, as a common denominator, compared to a race course? What is bringing these three together? What is yes? Okay, so someone says they are all indoors. They are all enclosed. Yes? There's an enclosure. Does rain go inside usually? What about a race course? Is it so? If you agree with this person that says these three form a class, and this class basically is that they are an enclosure. Do you agree with that? Yes.
If you say that, then what about a casino? Or you can't say that about being indoors. What it's more to the point, the house office room is privately owned.
Okay.
Whereas the other establishments could be owned by businesses, several companies.
So someone is saying what's actually common between these three is that they are what? Public? They are establishments? A house, office, or a room? Do you think that a house is an establishment usually?
Oh, I meant the other way around. They're not establishments, but
Okay.
race course is.
So what about an office?
An office can either be a working office or it can dwell within a house.
Okay. So is there at least the possibility that the office would be a public place? Okay. So do you think then that that's a strong argument to link these three together as a class? Can you find another argument?
It depends. You can have open offices like an agency.
Yep. What about house and room? Can you find an open room? In the sense of what? Open in what sense? It doesn't have a ceiling? So we said the three here could be put together as a class when we say that they are all enclosures. And someone's trying to poke at that, saying that no, they don't all have to be enclosures. Can you think of a way where these three cannot be enclosures? And still have a class? So common denominator?
Not licensed.
Not?
Not licensed.
None licensed for gambling. So this is what we say, it's a catch-22. You're trying to explain the thing by the thing that we were trying to explain, right? Not quite. It's not exactly that argument I'm looking for. Can you poke something in the argument that all of these are enclosures? Is there anything else that brings them together? They are owned places. Huh? Something around being owned by someone? What about a race course? Is that something that's owned by someone?
Yes.
So is that a helpful argument for you?
No.
So what I'm trying to say here, if you want the race course to be caught by the class, you would define it in a certain way. If you want the race course not to be caught by this class, you would define it in a different way. So there's no right or wrong. What do you want? You've tried to argue for that. Yes?
I was going to say that you can get indoor race courses as well, which kind of really muddies the water too.
Exactly. So this is what we want. What we want is to see that you can do something like critical thinking. Not necessarily coming to a conclusion, yes or no. You know? You try to play the role of the devil's advocate, try to see what's missing or how you can move it to this side or to that side. That would be the best mark you'd get. Not necessarily just saying yes or no. You show me if I do it this way, then that's going to happen. If I do it, so we can see that this guy is actually thinking. Okay, if the act reads, this is a variation. House, office, room, or other place, what did I say? Wheresoever. So the act now is not just simply saying other place, it says other place wheresoever. How does that change your answer in relation to a race course? So the argument that they are enclosures, is that good enough anymore? It will fail, right? Because they say wheresoever. Okay? I know, but it takes time so that you can actually appreciate the changes that could happen simply from adding or subtracting a word. Let's finish off on this idea of delegated legislation. Because of the technical nature of some legislation, So it requires certain technical expertise. And because Parliament really, the people who we get elected to Parliament don't have that expertise, they delegate, okay? They delegate the passing of these, of that act or legislation to what's known as subordinate authorities. But as you would imagine, there are always checks and balances on these authorities to make sure that they don't, go ultra vires and exceed their limits. Okay, let's park it here for, so let's just come back at 2:45, please. 2:45, and we'll start on our tutorial, which will take us through more examples for the assignment.